Okay, well, welcome to the March edition of our monthly Sprintlaw webinars, and today we'll be talking about employment law. The title of the presentation is Hire Right Your Legal Obligations as an Employer. I'm Alex, I'm the co-founder of Sprintlaw. Before we get into the educational content for today, just a quick introduction or reintroduction to who Sprintlaw are. For those that don't know us, we're an online law firm really designed to help startups and smaller businesses access affordable legal services. We don't charge by the hour like traditional law firms. If you need sort of legal advice, everything's done on a fixed fee basis, covering all the different areas of law, setting up your business, terms and conditions, IP, privacy, contracts, or as we'll be talking about today, employment law stuff as well. We also have an optional membership. About 90% of our clients end up signing up because it's pretty low cost and it's got a ton of features. We've recently given it a big upgrade. So as a Sprintlaw member, you can log into our platform. There's a bunch of free documents you can get in there. There's a legal health monitor where we learn a bit about your business and can let you know what your legal priority areas are. There's some AI features for some instant advice and for AI doc reviews. We've recently launched an AI email tool for anyone who hasn't checked it out already. If you log into your member account or make one, all of our members get a dedicated email address they can send stuff to as well. So a ton of features for legal help in there as well for those who might be interested. We've been around for about 8 years. We have a bit over 7,000 clients. We're in Australia, the UK, and New Zealand, and have won lots of industry awards. So that's a bit about us. And if you are sort of needing some legal help off the back of today's presentation or otherwise, we offer free consults. One free consult for those who aren't already members, or if you are a member, you've got unlimited quick calls with our lawyers, so you can log in and book a call. This for the next 30 days as well, we're doing some discounts on employment-related legal services. So let's talk a little bit about employment law. What we'll be running through today is starting off with the basic legal requirements that every employer should be aware of. What is fair work? What does it require of an employer in relation to employment laws? We'll be going through the different types of employment, casual, full-time, part-time, what's the differences, what do they mean? The documents that you might want to put in place for your business, for employees or otherwise. We'll touch on the tax, how pay works, superannuation. Then we'll talk about workplace policies that you might want to put in place. And we'll also be talking about the recent closing the loopholes laws that people may have seen in the news last year. There was a bunch of changes to employment laws, and it's worth being aware of what those changes are. Some of them are coming into force this year or in the next few months. So kicking off with fair work requirements, for anyone that is going to be an employer in Australia, there's sort of three kind of big pieces of law that you want to be aware of. Sorry, I should mention, if anyone has questions along the way, we've got a Q&A feature in Zoom. So do feel free to drop the questions in and I'll try and answer as I go, but I'll also leave a little bit of time at the end. So as I was saying, three sort of main legal requirements every employer should be aware of. The first is the National Employment Standards. So this is the sort of a piece of law under the Fair Work Act that applies to every employer, regardless of industry, regardless of what state you're in. And it basically has the national minimum wage in it. People can't be paid below the national minimum wage. It has standards around maintaining a safe workplace and free from discrimination, other sorts of things, and some other basic around sort of 10 standards that everyone sort of needs to comply with. So that's one thing everyone should really be across. And again, you can have a look at the Fair Work website and get across exactly what they are. There's an obligation for employers to provide every employee with a document called the Fair Work Information Statement. You have to give them this document by law. The document essentially summarizes the national employment standards and is in a digestible format so people are aware of what those standards are. And finally, we have modern awards. And so, in different industries, in addition to these national employment standards, there are sort of industry-specific requirements that sit on top of them. So, beyond the national minimum wage, there is a sort of legal industry award. If you're in the legal industry, there's a restaurant industry award. There's a sort of health sector award. There's all these different industry specific requirements. And again, based on what industry you're in additional to those national employment standards, there may be other sorts of requirements that you need to comply with in terms of overtime, breaks that you give, certain pay rates for different skill levels. So what you should be thinking about if you're an employer is, first of all, am I complying with those basic employment standards that apply to everybody? Have I got a safe workplace? Am I paying generally above the national minimum wage? And then secondly, what industry am I in? And is there any requirements on top of those basic requirements that may apply? So for example, for Sprintlaw, we're in the legal industry. So when we employ our staff, we of course are complying with those national employment standards. And we're providing this Fair Work information statement, summarizing them to all of the people that work at Sprintlaw. And we're also complying with the Legal Services Award, which is the one relevant to our industry, and making sure that all the different roles in our business, from our administrative staff through to our paralegals and so on, are complying with the different pay rates, overtime requirements, and break requirements in the modern award, as well as some record keeping requirements, which are specific to the legal industry. So again, if you think about what industry you're in, you might want to figure out what your award is and what the requirements are. And I see someone's just asked, where can we find a list of modern awards for each industry sector? The Fair Work website, which in general, by the way, is a really great resource, sort of free resource for learning about all of this stuff, has a awards list. And in fact, I think even has an award finder tool where you can, it's not the easiest thing to use, but you can kind of describe your business or select your industry, and it will try and pick out which awards may apply to your business. In many cases, it's clear. I should mention, in some cases, you might get confused because you're not sure which industry you're in, particularly if you do a couple of things. And it can be hard to work out, and often you may need to engage lawyers to give you an assessment as to which award applies. For example, we have a lot of businesses who aren't sure if they're restaurant award businesses or fast food award businesses, and often there's a bit of analysis required. And it's important because it really goes to how you run your business. So do have a look online, and of course, if you're confused, we're happy to sort of help out. So those are the kind of basic legal requirements. So just to dive in a little bit more into those national employment standards, I mentioned the minimum wage. There's also a maximum weekly hours for full-time employment. There's a requirement as of more recently that people can make requests for flexible working arrangements after working with you for 12 months. There's, again, more recent laws. Everyone's entitled who's a casual employee to potentially request to convert from casual to permanent. There's basic leave requirements for permanent staff, amounts of annual leave, personal carers leave that you have to provide, and other sorts of leave. There's superannuation contributions, and there's termination notice requirements. So again, there are these 10 minimum standards. Of course, some in this list are specific to casual and some are specific to permanent staff. But this is the sort of stuff we're talking about that, in general, every employer needs to be complying with regardless of industry. The Fair Work information statement, as I mentioned, really summarizes a lot of that stuff. So it's got those national employment standards listed in there, as well as all of the different rights that the individuals have. And this is sort of conceptually important because even though there is this piece of law, the national employment standards, it can be difficult to digest, and it may be that your employees don't understand what rights they have. And this is why this sort of PDF document was prepared by Fair Work, and it is a requirement to send it. So really on the first day or prior to the first day of your new starter, you should be sending them an email that says, please see attached to your Fair Work information statement. And you can just download that off the Fair Work website. And I touched on the awards as well. And so, here are some examples of awards. As I said, there's many of them. Legal Services Award, Hospitality Award, Fitness Industry Award, Hair and Beauty Award, Health Professionals and Support Services Award. For those that don't neatly fit into any award, there is, for many private businesses, a kind of fallback award called the Clerk's Private Sector Award. It's not the case that every industry is covered by an award. It is possible for your industry to just not be listed and not covered by the award, although it's quite rare that there isn't at least one award that may apply to you. someone's asked, is there a SaaS award? There isn't a SaaS award, but there may be, depending on what industry you're. So without getting too legally nuanced, awards are largely industry related, but can also be job specific. So they kind of cut two ways. So there is various technology related awards which may apply to technology employees in a SaaS business. This Clark's Private Sector Award may apply to non-technology specialist employees working in a SaaS business. So there isn't one specific for SaaS, but there may be a couple of awards that apply to different roles in your business. And again, you sometimes see businesses who are a software business in a particular industry have to kind of comply with two different awards depending on the type of employees that they have. So it's not necessarily super straightforward to work out, but depending on what your SaaS business does, it's likely that some awards may apply. And again, you can have a look yourself on the Fair Work website, but it may be something to get legal advice on. We've had a good question as well. Who decides which award is correct? And if we choose the wrong one, can we be in trouble? The answer is yes, you can get in trouble because, of course, under these awards, there are requirements. For example, if someone has a shift of longer than X hours, you have to give them a break. If someone works on weekends, you've got to pay them prescribed overtime rates. So if you've picked the wrong award and said somebody's under A award when they should be under B award, you may have inadvertently breached all the requirements of B award and underpaid people. So, you could be liable for back pay. You could be liable for fines and penalties from Fair Work. Now, who decides who's correct? Ultimately, the regulators can make some decisions, and in complex circumstances, they do. Sometimes it's, if it's really nuanced, it can be subject to a legal battle. There's been legal battles where employees have engaged lawyers and said they were under the wrong award. And the employer said, no, we think it's this award, and they've gone back and forth, and a decision was sort of made by a judge. So it can get quite nuanced. In general, what will happen if you can't figure out what award you're in? By the way, for many businesses, it's not very complicated. If you're a hair and beauty business, it's going to be the hair and beauty industry award. But for these gray areas, you would go and seek legal advice, and we would sort of say, look, we think there's a high probability, we can't say for sure, a high probability you'll be under this award. And, most of the time you'll be pretty safe if you get that advice. And, if the advice turns out to be wrong, you can always go back to your lawyers and say you got it wrong, and that there may be some claims. But again, usually it's possible to work out which one's more likely. And if it's really in doubt, a lawyer might suggest you comply with two awards. But again, I don't want to give the wrong impression that this is going to happen to everybody. We're really talking about edge cases here. For many of you, it should be pretty straightforward to work out which award it is. It won't be too controversial. And, as long as you comply with it, the likelihood of getting fines and penalties is pretty low. So minimum wage is one of the requirements under the NES. Again, the way to understand what you need to pay your employees, as I've sort of been saying through the last few slides, is there's two levels to it. There is a national minimum wage, which is currently 23.23 per hour. But that's not the minimum that you necessarily need to pay your employees. Once you figure out what award applies to your business, there may be a higher minimum wage based on what their role is. And each award, if you, again, pull out the awards on the Fair Work website, they're 5 to 10 page documents. You can view them as a PDF, or you can view them in your browser. Usually at the back, they've got a little table, and they'll say people that do a job like this must be paid at least 26 per hour or 30 per hour if they're a casual. People that do a job like this have to be paid 30 per hour or 35 per hour if they're a casual, and they'll often have levels, if that makes sense. So what you're going to be wanting to do for your business is work out which award applies, figure out the role that you are engaging, what is the pay rate for that person based on kind of what the role description, which one does it match in terms of those levels. And again, people may have seen on the front page of the employment contract, oftentimes you'll say to your employee, here is your employment contract. You have been classified as, level 3 under this award, and therefore your pay rate is kind of covered by that. So that's kind of how it works. You can pay above the award rates. Obviously, in many jobs, you'll be offered an annual salary, and it may be an amount above the awards. In general, that's fine. You can certainly pay above the award rates. But the amount that you pay, let's say you pay just a fixed annual salary, but your job requires the person to work on weekends. And had they not been on their fixed annual salary and had been on the award rates, they would have ended up being paid more in a year than they're paid under your annualized salary. That can be a breach of the award. And again, the employee can request top-up pay, or there could be a final penalty. So for those that, and many organizations do this, that just want to do a simple annual salary for people, you've just got to double check that it's enough above the award. And based on what the role is and the hours they'll be working, that you are at least ticking the boxes as if it were under award, if you just want to sort of do an above award rate. So that's kind of how it works with salaries. Someone's asked, where can we find a list of modern awards for each industry sector? I think we have that on screen here, but again, Fair Work website. For a lot of the stuff I'm going to talk about today, Fair Work and whatever you want to know about, there's likely to be a page there. But if you just type in Fair Work Awards onto Google, you should be able to pull it up. So we've covered those real basic sort of legal requirements, your NES, obviously the information statement you've got to provide, and then figuring out your industry's award. Now let's talk a little bit about employment types. So when you're engaging someone to work for your business, there are a few different ways you can engage them, and based on how you engage them, the legal requirements are a little different. So, the first category we have is full-time. Someone works for you for, I think the Fair Work regulations define that as 38 hours a week or more is considered full-time. People can be engaged part-time. Maybe they'll work 20 hours a week. People can be engaged on a casual basis. Their hours may vary from week to week. They may be subject to a roster system. People can be independent contractors, so they're not actually sort of part of your business or really an employee of your business, but rather they have their own sort of business number or business, and they'll contract for you. Or finally, there can be interns that you may take on, which may be paid or unpaid. So we'll just run through each of the types and go into a little more detail in terms of what they are and how they work. So full-time, part-time, I mentioned around 38 hours per week with ongoing employment. If you're a full-time employee in Australia, you're entitled to annual leave, personal and carers leave, long service leave, parental leave, and a few other leaves I kind of mentioned on a previous slide based on your full hours of work. So of course, if you're employing someone on a full-time basis, you have to give them this amount of leave. They will accrue their personal carers or what we often call sick leave over time. They are entitled to 4 weeks annual leave per year. And so if you try and engage someone on a full-time basis and you don't give them their basic sick leave entitlements and you don't give them their basic annual leave entitlements, you're breaching the law. And again, you could suffer fines or penalties or a claim from the employee for not giving them their benefits. So it's very important, if you're engaging someone on a full-time basis, that you are giving them all of their legal entitlements. In addition to the pay that they're entitled to. Part-time employees, and by the way, this, when we say full-time and part-time, we're talking in this case about sort of permanent employees that you may have. Although you can, which I'm not really going to cover in this presentation, also have fixed-term employees where you employ someone for a fixed period, and the requirements are largely the same with some small differences. But if you're a part-time employee, part-time permanent employee, your legal entitlements are very similar to a full-time employee. Everything is just sort of prorated. By prorated, we mean if you work, let's say, half of a full-time load, so you work 19 instead of 38 hours, your entitlements to annual leave go down from 4 weeks per year to sort of 2 weeks per year. And similarly on the personal care leave front, you'll accrue sick days at a sort of half the pace as someone working on a full-time basis. But otherwise, it's the same entitlements, the same types of leave that you get. It's just proportional to the hours that they work as compared to a full-time load. So that's kind of how part-time works. Now talking about casual employees. So a casual employee is somebody that will work for your business, but they don't get a firm commitment of a certain hours of work. Each week it may change, each fortnight it may change. And that's the third type of employee that you might want to take on. And they're different to your part-time employees because your part-time employees are sort of told for the period they're engaged. Each week they're going to get the same regular number of hours and they're going to get these entitlements. The casual employees, you can't promise them that you'll always have enough work for them. It may change all the time. You can't promise them a certain number of hours. And that's kind of the basis under which you're employing them. So it's obviously more flexible for employers. And one of the features of casual employment is because the casual employees, may get no work or they may get some work, the law says that in general, you don't have to give them all of these same entitlements in terms of annual leave, personal carers leave, long service leave, parental leave. As a result, however, under most awards, casual employees' minimum wage is higher than it is for non-casual employees because the law recognizes that these people are more at risk. They're not getting all their leave entitlements and they should be entitled to a loading or a higher pay rate in consideration of that. So casual employees can be more expensive under law than permanent employees. Although, when we say more expensive, it's on a cash basis because they're not really, you're never going to have to give them sort of the paid or sick leave that you may have to give the other types of stuff. So that's the trade-off with the casual employees. That there's the loading, but there's no sort of entitlements. In addition, and this has changed a bunch in the last couple of years, there's some new laws that have been introduced to further protect casual employees. Because obviously, if you're a casual employee, there are risks for you. You may not know whether you're going to get work or not in any given week. A lot of employers had been operating with large number of casual employees, who they would switch on and switch off. And we've had recent law changes that have basically said that if a casual employee works for over 12 months for an employer, and there's some more nuance that I'll cover kind of later on in the presentation, but in general terms, if they work over 12 months, they can request to their employer to be converted into a permanent employee, into a permanent part-time employee. Now that request can be refused, and we'll go through the law on that in a moment, but has to be on reasonable grounds. So if you are engaging these casual employees for an extended period, be aware that they can make this request, and you have to seriously consider converting them to a permanent part-time basis, giving them ongoing employment, and giving them access to those leave entitlements. In addition, there are certain leave entitlements that they get access to sort of after 12 months as well, even though they're a casual. And again, some of that's under the new employment laws I'll cover in a moment. Now, while I mentioned earlier, there's the FWIS, Fair Work Information Statement you have to give to all employees. If the employee is a casual employee, there's something called the Casual Employment Information Statement, which you also have to give to them, ideally on their first day or earlier, explaining to them these extra rights. Because casuals, as I've mentioned, have extra rights on top of the full-time and the part-time employees. So again, you can get that off the Fair Work website, and it's a PDF document that you just attach to an email when they start work. But there is a legal requirement to give them this CEIS, so definitely worth being aware of for anyone that has casual staff. I've seen a few questions on casual employees. We've got a question for casual employees. Do they receive overtime rates as well? It depends on the award that they're in. But yes, in general terms, if you figure out your industry award, go onto the Fair Work website and have a look at the table at the bottom, you will often see that, there's, first of all, different pay rates for full-time, part-time, casual staff at different levels, and then different overtime rates as well. And again, casual employees can be entitled to higher overtime rates than their full-time or part-time equivalents. So the answer to that is yes, they can receive overtime depending on the award. Again, overtime is not in the national employment standards. So, some awards may not have overtime as a concept, but the majority do. And again, casual employees are generally entitled to them as well. Jessica's asked, if a casual employee is being paid above award, are they still entitled to the 25% loading? No. To clarify, if you pay them an amount of money that is more than they would have made if you just paid them in accordance with the award, then you are considered to be compliant with the award. Of course, you've got to get your contract drafted correctly to clarify that. The only concern is when you pay them above their base rate, but less than what they'd get with the loading. And then they say, no, I would have been entitled to this much had you just employed me under the award instead of paying me in the way that you're paying me. And then there can be a kind of claim made. So that's kind of how that works. So no, you don't have to give them 25% above the number you write in the contract, but the number you write in the contract has to be enough so that it's more than the 25% loaded. And Robert's asked, if we pay someone a big enough amount that is above allowances and hourly rates, is that allowed, or do allowances still have to be paid on top? A similar question, but you can't sort of pay somebody such a high amount of money that they would then waive their right to sick leave, for example. The actual specific allowances are baked into the way that employment works in Australia. So the allowances do have to be paid or honoured on top of the base pay rate. So yeah, they're enshrined into the law. So I think that's what you're asking, and that's kind of how that works. We just had a question about travel allowance. Travel allowance is not, in most awards, and Robert's also clarified he's talking about other allowances. Okay, so yeah, for both of these two questions, if you're talking about allowances other than these entitlements, leave, personal care leave, so travel allowances or first aid allowances or whatever it is, those things are in most awards, they're not a legal requirement. So if you want to pay somebody more and say this amount includes, covering costs that you may incur for X, Y, Z in the course of your employment, travel or whatever it is, you can do it that way. Other times, employers choose to not have it all inclusive and will pay a wage and say you're also granted as a perk this much money to cover travel that you may do in your job, provided that you provide a receipt and submit it to our team as proof of travel. So there's different ways to do it. You've got to be careful because and this is getting more into tax and legal territory, but there are sort of taxes that might have to be paid on certain allowances. There's a law around fringe benefits. So if you're giving people like a entertainment allowance, there can be tax requirements that apply to you as an employer around those allowances. So it's not completely straightforward. But in general, the allowances are sort of a private matter for you to kind of work out. And again, a lawyer can help you design an agreement that includes the allowances or excludes the allowances, depending on how you want to do it. But there's not specific laws other than that fringe benefits tax that really control how you have to manage those allowances. It's really all about these basic requirements: annual leave, personal carers leave, and all those other sorts of leave. So hopefully that answers those couple of questions on allowances. So now let's move through to independent contractors. So what is an independent contractor and how is it different to an employee? So I mentioned earlier, independent contractor is a self-employed person who really runs their own business. They're responsible for their own taxes, insurance, and superannuation. And you are engaging them to kind of help out with your business to do sort of some form of labor to assist with the way that your business operates. Now, as we'll cover in a couple of slides' time, one of the big differences is when you employ someone, whether it's full-time, whether it's part-time, whether it's casual, you are required under the NES standards and also tax laws to pay a certain amount of superannuation to them to handle their income taxes and there's administration you've got to do on their behalf. You've got to issue pay slips and all those sorts of things. When you engage an independent contractor, it's a much lower administrative burden. You just will pay an invoice that they issue you. You don't have to necessarily pay them superannuation. You don't have to handle their taxation. It's really just kind of paying a bill to a person helping you out. So again, it can be very attractive to businesses who don't want the burden of guaranteeing employment, or even having to have a casual employee who's got certain rights and all of the administration that comes with having an employee. You may prefer to work with an independent contractor. And that's okay and may make sense for certain kinds of roles depending on how your business is operating. Now, there's a few things to be aware of. First of all, independent contractors, of course, generally will cost quite a bit more than employees because they've got to manage their own business and their own bills. You can't also pretend somebody is an independent contractor running their own business, but really they're actually an employee and you're just trying to avoid all these legal requirements around minimum wages by calling them an independent contractor. And there's been many cases over the years of businesses sort of setting up, making everyone be a contractor and then paying them below minimum wage or not giving them overtime or et cetera, et cetera. Now, that may be okay if they are truly independent contractors. They've signed a private agreement with you and they're happy to work at whatever rate that you've agreed to work at. But the law will override your contract with them if the law deems or decides that really this person is an employee and you're sort of taking advantage of them in the way that you've structured things. And there is this test that exists under the Fair Work laws, which basically says if somebody is claiming to be an independent contractor, but really you control a lot of how the work's performed, they don't take on any real risk. You're still taking across the risk. You're providing all the tools and equipment. Maybe you're providing a uniform for them. They've got no ability to delegate it or subcontract it. They have to personally do it. They're doing regular hours and it's happening all the time on an ongoing basis. If these criteria are met, the law will say, hey, you guys might have tried to call this an independent contractor arrangement, but in fact, you've got what we call a deemed employee and you should have been paying them super and you've been breaching these laws. And so if you misclassify or treat an independent contractor as an employee, you can be liable for fines and penalties as well as back pay, as well as a need to pay things like superannuation. So and this is called sham contracting, which we kind of have at the bottom of the slide, where you pretend someone's an independent contractor, but really you end up in practice treating them like an employee. So you have to be very careful with your relationships with independent contractors. Really, you should be paying them on an ad hoc basis. You're not paying them necessarily, if you can avoid it, although it may not always make sense, for the hours they work. It's kind of more for deliverables or goods or services. That you ideally want them working for other people, having some autonomy over how they work, making that word independent really feel true. And if you're engaging them in that way, the law is okay with you working this way, but it's when you start to really try and avoid having them as an employee that the law doesn't really like it. And it doesn't matter if they have personally said, I don't want to be an employee, I want to be an independent contractor. In most cases, even if they don't personally want to be an employee, the law may not care and it will give them these rights. And again, there could be penalties and consequences. So this is a big area where we get a lot of questions because a lot of smaller businesses are using independent contractors. And sadly, sometimes they have happy relationships with independent contractors for a few years until someone tells the independent contractor at a barbecue that, they should have been getting paid super or they should have, been paid overtime because they're really an employee and, a dispute emerges. So you just want to be proactive and careful in the way that you manage your independent contractors. Jessica's asked, is there a separate classification for people engaged under a service agreement rather than an independent contractor? No, the title of the agreement doesn't really matter. You can call it whatever you want: service agreement, goods and service agreement, client service agreement, independent contractor agreement. Ultimately, if someone is providing labor, sort of like human services, to your business, then they're either going to be an employee or a contractor. There's only really two questions, if that makes sense, and the law will apply this test. So it's totally possible to have done a service agreement with someone, but it turns out they are found to be a deemed employee. or of course, more commonly, you do a contractor agreement with somebody and they turn out to be an employee. So yeah, the name of the contract doesn't really matter in terms of this test. So that's a bunch on contractors. We'll quickly touch on interns. Again, this is a question that we get quite often. So, you've got your employees, you've got your contractors, and then sometimes you may want to take on an intern. Oftentimes for smaller businesses, they want to use an internship as a way to get some free help while providing some helpful experience to the person. Interns in general are subject to the same minimum wage laws. So you've got to be careful if you want to do an unpaid internship. Now, there's a couple of exceptions in the Fair Work Act to allow unpaid internships in limited circumstances. And there's really two exceptions. One is if the person's doing it as part of a course or a degree. If they're getting course credit or diploma credit or whatever it is for completing a work placement, then you're allowed to do an unpaid internship. So this is the exception we recommend most of our clients rely on. Only take on interns that are doing it for a course, and then you're quite squarely okay if you want to do an unpaid internship. Otherwise, there's another exception. It's a little bit of a riskier exception in my view. You can also take on unpaid interns if you are giving them what the law calls genuine work experience, although it doesn't really define that very well in the Act, and it essentially means that the internship is designed so they get more out of it than you, i.e. they're genuinely sort of shadowing you and just learning rather than commercially contributing to the business. Now, it's quite subjective. In a lot of the cases that have been tried on this, it's been found to be the other way around, where the business got more out of it than the intern. Our view at Sprintlaw, and again, other lawyers have other views, is that this second exception is pretty risky to rely on. And if you're not going to pay someone, it's much safer to do it as part of a student placement. Important to understand that. Otherwise, you can certainly take on interns, but they would have to be paid the minimum wage requirements and essentially be a casual part-time or full-time employee if you can't sort of slip it into one of these exceptions. So, an important point to keep in mind for those who are thinking of taking on interns. So we've talked a lot about the compliance requirements, the differences between awards and NES. We've talked about the different types of employment and engagement models. What do you actually have to do is the next question. What is your to-do list for getting people set up as employees? Well, the key thing you want to get in place, if you don't have one already, is a contract. For your full-time, your part-time, your casual employees, or I guess your interns, you have an employment contract. Most people would have seen one of those before. It's a 5 to 10 page document that says, we are this employer, this is your role, this is your pay rate, here are your entitlements. You agree to do a good job. You agree to keep everything in our business confidential. You agree that anything you create in the business, any intellectual property is owned by us. You agree to treat our property safely. And if the employment ends, we may put you on performance management if you're not doing well and terminate it in X, Y, Z ways. So that is a very important agreement to put in place. And it's not specifically required by law that you have to have a written agreement with all the stuff I just said, but it's very, very important to have something like that in writing, or there's all kinds of risks. Your employees could go off and steal your stuff. You could be claimed to be breaching employment laws because there's nothing you have in writing that says that you're complying with them. So it's just a really, really good idea to have a proper employment agreement for each of your employees, and it will cover us a whole bunch of risks. So definitely want to get one of those. On the contractor side, if you're taking on an independent contractor, same goes. You want to have a contract. It looks quite different to the employment agreement because there's not, leave clauses, entitlement clauses, superannuation clauses, all those sorts of things. It's more like as per the question earlier, a service arrangement where the contractor is going to provide you with some kind of service in exchange for some kind of payment. And it'll talk a little more about like invoicing terms, liability terms. Again, it'll have confidentiality and intellectual property stuff, but it's a bit of a different document. So again, if you're taking on independent contractors, you want to have a contractor agreement. In practice, what we do for a lot of small businesses is we'll draft a standard employment agreement, maybe a full-time one, a casual one, and we'll also give them a contractor agreement. So they may have 3 templates. And then each time someone starts, they just kind of fill in the name and details and can send it out and get signed. And you generally don't necessarily need a lawyer every time once you have your business's templates. unless you're doing something creative, like you're introducing a bonus scheme, or it's a new type of role, or it's a new business line, and you're worried about awards or something curly comes up. But in general, a lot of businesses just have the templates and will reuse them for different situations. So a couple of questions. Assuming I already have employment contracts with existing employees and I have Sprintlaw draft new employment contracts, how do I roll out and update my employees' existing employment agreements? It's pretty straightforward. You would just send them the new employment agreement. We can draft an extra paragraph into the new employment agreement that basically says, this agreement supersedes your prior employment agreement, and we'll override it to the extent of any inconsistency, or terminates the previous one. So we can have a simple clause in there that will override it. The only complexity would be if there's some change in entitlements. That's more for you than a complicated legal question. If you're giving more leave, you'll have to make sure you update your leave processes, or if you're introducing a new policy, you'll obviously need to make sure that policy is rolled out. But in general, in legal terms, it's fairly straightforward. It's just an extra paragraph in the new agreement, and then you just get them to sign it. But they do have to sign it, and it's important to mention that in employment agreements, you can't force employees to sign a new agreement, and they may refuse to do so, and then you may be stuck with their old agreement. So oftentimes it's the way you communicate it and explain if you want to sort of get them to sign it, and we can obviously help you with how to manage that process. And another question, should you offer a standard contractor agreement or accept the contractor's document? Another great question. Look, I think either works. The risk of accepting the contractor's document is it's going to be better for them and worse for you. And it's better off if you've got one that's good for you and protects your interests rather than their interests. So it depends on the situation. It depends on the contractor. It depends how important the relationship is. And certainly at Sprintlaw, we have lots of contractors. And for certain contractors, like our legal contractors, we are very insistent that we use our contractor agreement, because what they do for us, they assist us with providing overflow legal advice and so on. We need to make sure we got a rock solid agreement with them. For people that might come in and sell us, a single laptop or a computer, or help, that's really a goods agreement, not really a contract agreement. Someone that comes in and assists with an IT problem or something like that for a couple of hours, it's probably not a big deal to insist that they sign our contractor agreement, even though whatever they've sent us probably has all kinds of protections for them and so on. So in general terms, it's better to use your document. But again, I'm not suggesting that you have to be doing that in every single circumstance where it's impractical. It's just that the documents will be different. And when I say different, there's a couple of things that may be different. Like if it's your contractor agreement, the invoicing clause may say you've got to send us an invoice with plenty of notice, and we'll pay it when we can pay it in accordance with our timelines. Whereas their agreement may say, we can issue you an invoice, you better pay it within 7 days, or I'm going to charge you interest on it. And so you can see that's worse for you, better for them, if that makes sense. Or similarly, liability. If something goes wrong, your agreement might say you've got to fix, if you make a mistake, contractor, you have to come fix it for free because you made a mistake. Whereas their contract agreement may say, if I make a mistake, but I did my best, too bad, you got to pay me more to fix it. So again, better for them, worse for you. So that's the consequence of deciding which one to sign. So you can see in general terms, better to use yours, but in practice, you may decide sometimes you're happy to sign someone else's if it's a low risk situation. I've covered some of this already, but just to dive in a bit more detail, inside your employment agreement, the types of things that we're seeing in there are salary, leave, probation if you're going to do that, IP ownership, confidentiality, termination rights. The contract cannot have stuff in there that is inconsistent with the National Employment Standards or the modern awards. And there is some free templates on the Fair Work website for full-time, part-time, and casual contracts, which are consistent with the NESO modern awards. In practice, a lot of our clients don't use them because they're pretty employee friendly. They don't cover a ton of important issues around IP ownership and confidentiality. They're often not tailored to your particular business and what you do. So again, I wouldn't necessarily suggest using those unless you're really, really cash strapped. And again, as per the question we had earlier, if you set up on sort of cheap and quick contracts, it can be hard to move off them in the future. So it is probably a good idea to invest in a good set of employment agreements early on for your business. But there are free templates available for those that want to check them out. And on the independent contractor side, those documents are similar, but as I said, different in structure. They're covering the services, the payment, liability, who's liable if things go wrong, again, IP confidentiality, can they subcontract to other people, and termination, how does it end? And as I've said earlier, be very aware of treating these independent contractors as employees, but calling them contractors on paper because there can be risks associated with that. Rick's asked, is there any implication of using the term permanent versus fixed term in conjunction with full-time and part-time and related accrual of long service leave, etc.? So there, in relation to the leave benefits, it's pretty much the same for permanent and fixed term employees. You're still going to accrue, your long service leave, your annual leave, your sick leave, as if you were, well, I should say, you can have a permanent fixed term and a casual fixed term contract. But if you've got a permanent full time or a fixed term full time, which I think is kind of what you're asking, the leave rates will be accrued pretty much the same. There's some small differences which come up rarely, which is why I say pretty much, but it is pretty much meant to be identical. The difference with a fixed term employment is that it has a natural end date, whereas a permanent employee, let's say you put someone on an 18-month fixed term contract versus a permanent employee that has no end date. At the 18-month point, if the fixed term contract isn't renewed, it can just end. Whereas for the permanent employee, if after 18 months you wanted it to end, you've got to carefully consider why it's ending, consider unfair dismissal laws, consider notice periods, and a bunch of other considerations. So it's harder to end the employment if it's not fixed term. But of course, many people wouldn't sign fixed term contracts because they want security of employment, which is why they're not used all that much in the workplace. But yes, that's the main significance of difference, but the leave accruals and everything are pretty much the same. Julie's asked, where do enterprise agreements fit here? Not really going to cover them in this presentation. They're more for larger organizations, but just to briefly touch on what they are, there's these things called enterprise bargaining agreements, which particularly for large employers, for McDonald's or Domino's or Pizza Hut or whatever it is, their employees are such a large number of employees that they often will negotiate standard terms with the employer now, which are better for specifically the employees of that specific organization. Now, there's a bunch of laws around those. Those enterprise agreements can, in limited circumstances, actually override some of the basic modern award requirements. For example, McDonald's is in fast food, but it may be that they have an enterprise agreement that is actually non-compliant with aspects of the fast food award. But in order for them to do that, they may provide other perks and benefits to get their employees to agree to it. And they have to go register it with Fair Work, who will assess what they're trying to do and say, okay, well, you're not paying as much overtime, but you've agreed to, provide XYZ additional perks to your staff. They all seem to be happy with it. And then it gets registered. And, then the employees of those large organizations, have a little bit of a different arrangement to what's kind of the generic place under law. So that's kind of how they work. We do sometimes see small business employers try and do that stuff. It's very expensive to go through that whole process, and it's rarely worth it. But and that's why we don't cover it in this presentation. But it is an option for those that, if the award is really challenging for how your business is operating, that's one way to kind of get Fair Work to give you an exemption, if that makes sense. Another question, if a contract is based overseas and sends an invoice for work completed, is it less likely they can claim being an employee than if they were a local here in Australia? Good and difficult question to answer. In general terms, if someone's based overseas and working for you and they meet that test that I mentioned earlier of regular employment, working under your control, et cetera, there is for sure a risk they could say they're an Australian employee. There's also, depending on what country they're in, potentially complex, double taxation issues to be considered. Do they pay tax to the Australian government or their local government? How is this managed in practice? To be honest, a lot of people that are doing offshoring ignore these risks, do what they want, and are probably breaking some laws, but it's never really reported. So if you're wondering why this doesn't seem to be so complicated in practice. It's because it's not necessarily completely legal what a lot of people are doing, and it is actually quite complex. But a crude way of understanding why it often works out is oftentimes your overseas contractor will have a contracting company. And so you might actually not be employing them directly, but you'll be engaging with a company overseas. And it'll be kind of you and a company signing a contract, and part of their arrangement will be to provide you with services provided by their staff. And the way that's structured can be often seen as like a pretty clear independent contractor arrangement and not falling under employment laws. So that's often how you structure it. But if you just have one person contracting for you overseas, not through a company, you are in a bit of a gray area in terms of a lot of this stuff, and they could be a deemed employee, plus there could be double tax risks and a whole bunch of other things. A lot of organizations like Deal and Remote.io, who we have partnerships with, for those that are members, you can see it in our office section. They provide a service of helping you engage overseas staff in a compliant way. And so I would suggest considering using them if you're thinking of having people work from overseas, either that or an established sort of outsourcing organization, because it can get complex. Another question is that, and there's a bunch here, so I might quickly continue on and come back to some of these later, but just to do one more, is the end date the only difference between the fixed term and permanent contract? It's the main difference. We'll come to, in a few slides' time, one other small difference for fixed term contracts. But in general terms, that's the main difference. But I should say, when you use the words fixed term, you can have a permanent fixed term and you can have a casual fixed term. So the only difference between a permanent fixed term and a permanent non-fixed term contract is pretty much the end date, with some small exceptions. But as I said, there's casual fixed term as well, and that's quite different to a permanent contract. So yeah. So let's continue through, and then I'll come back to the questions. We've talked about the agreements: employment agreement, the independent contractor agreement. Now let's talk about tax and superannuation requirements, and I'll just go through each of these three: tax, payslip, superannuation. So on tax, if you are employing someone, you need to meet tax obligations for all of your employees. And the two main things you need to do, or three main things you need to do, is, first of all, you need to do pay-as-you-go tax. So, when you're paying someone their wage or salary, you don't pay them their gross wage into their bank account. You got to keep a little bit based on their projected income tax obligations for their tax bracket for the year, and pay that amount with their fortnightly or monthly paycheck, or however you do it, directly to the government. And there's a system through which you do that, called the pay-as-you-go withholding system, and you can set it up with the ATO, or if you've got an accountant or bookkeeper, they can help you with that. But you've got to make sure that you're doing that. You can't just employ someone, agree to pay them $20 an hour as an employee, and just pay them $20 each hour. You're going to have to withhold some of the tax, give it straight to the government, and then give them the net amount after the tax has been deducted. So that's a very important thing to be aware of. And you don't want to find out you got a big tax bill you should have paid and you've overpaid your staff member, because it can be a messy situation. So make sure you get registered and set up with pay-as-you-go before you're paying people. And again, if it's all too complicated, oftentimes payroll service providers can help set all this stuff up for you, and you just pay them a fee to handle your payroll. Similarly, I mentioned earlier fringe benefits tax. If you're giving people special allowances, company cars, parking space, entertainment allowances, you might have to pay fringe benefits tax on those things. So if you're reimbursing people for entertainment costs, someone spends $1,000 on entertainment and you give them $1,000, it could otherwise be a way of avoiding the pay-as-you-go tax. So fringe benefits tax for certain types of allowances kicks in, and not all types of allowances. Some could genuinely be sort of tax-free reimbursements, but for some, you need to pay this additional tax. So that's worth being aware of. And finally, if you are, and this applies to people that have a reasonably significant number of employees, there's something called payroll tax that exists at a state level. Each state has payroll tax, and it's another form of income tax that you have to pay. And it can be sort of like a few percent, up to 5% of what you pay in your total payroll can be payable to the state government as well. So if you're a very small business employer, it's unlikely you meet the threshold. But if you're employing, many people, sort of like potentially 10, 20, 30, depending on which state you're in, and depending on the amount that you pay them, there's different exemption thresholds that you might pass, and then you'll have to start paying a state-based tax. So worth being aware of that. In addition to the tax requirements, you've also got to issue pay slips. They've got to be given to an employee within 1 working day of payday. And again, payroll providers can assist with this. There's a bunch of softwares out there where you can run your payroll through and it'll automatically generate the pay slips. But you do have to give them a slip explaining what you paid them, what the breakdown was, pretty soon after the payday occurs, or give them access to it. So that's another legal requirement. And you're required to keep those pay slips for a period of time, at least 7 years for each of your employees. So again, you can do this yourself. There's tons of softwares out there that help handle it for you, or service providers. And oftentimes we find small businesses find that a lot easier than handling it themselves. But it's important to do something because the tax and the pay slip is a legal requirement. Finally, we've got our superannuation. In terms of the way superannuation works, employers generally have to pay a percentage of an employee's pay into a superannuation fund nominated by the employee. You can, of course, have a default one if you want, if people haven't got a super fund. Usually it's paid quarterly for all of your employees, but it is on top of whatever you're paying them, and it's on top of the minimum wages. So these numbers here are a little outdated, but it's 11.5% as of July 2024, and it's going to rise to 12% on top of the base pay in July 2025. So again, important to be paying that as well. You can sort of set that up with the ATO. There is an exception for people under 18 years who work less than 30 hours a week. Super's not payable. But in general, that's an additional pretty significant cost for everyone to be aware of with all of their employees' pay. We're just at 2. We've got a couple more slides and a couple of questions, so I'll go for another 5 minutes. So feel free to stick around if you don't have to be anywhere, and we'll wrap up pretty soon. And I should say we'll have a recording of this that we will circulate inside the Sprintlaw members portal. We'll also shoot an email for those that want to watch any of it again later. So just to quickly wrap up with the policies, we've talked a lot about the legal requirements, the documents, the processes you need to put in place as an employer. Finally, people would have heard of workplace policies and procedures. Policies are, in general terms, not necessarily a legal requirement that you have to have a bunch of policies, but they are a very good idea as you start to have employees. One reason you want them is there's another piece of law called the Workplace Health and Safety Laws that applies to employers, which basically have an obligation on employers to provide a safe workplace for all of their employees. Now, one way you can show that you're providing a safe workplace is to have policies and procedures to make sure that people are behaving in a safe way. I mean, if you're a trades or construction business, maybe it's around the handling of machinery. If you're an IT business, maybe it's around the way that computer software and programs are used. There can be all kinds of ways that a workplace could become unsafe, and policies are really designed in many ways to comply with safety laws. They're also designed to comply with workplace laws. Again, there's laws around unfair dismissal that I touched on. If you fire people or terminate people's employment without following proper processes, depending on how long they've been working with you, they can make claims that they were unfairly dismissed. They could make claims they were discriminated against, and they can make claims that you've breached various aspects of the employment laws. So again, having a staff handbook with policies and procedures on how you handle communications, how you handle work issues, how you handle recruitment, other sorts of processes, as long as you follow them, that can really go to showing that you run a compliant workplace that's operating in a proper and structured manner and is complying with all the health and safety as well as employment laws. So very good idea to get these policies and procedures in place. For those of you who are Sprintlaw members, we have about 50 different policies available for free for our members, which you can generate using our free docs feature. So I'd encourage you to check that out. And I should mention, it's not just enough to download the template. You've actually got to read it and make sure that you're complying with that in the way that you run your business. But it's a great way to get started. And often your employment contract will notify your employees of the policies. It will say, by signing this employment agreement, you agree to comply with all of the policies and procedures in our staff handbook. That's kind of how the policy stuff works. Yes, I won't go through these in detail, but as I mentioned, a work health and safety policy is an important one, and you can have workplace discrimination, workplace bullying, sexual harassment policies as well. And the more of those you have, the more compliant you're likely to be with these processes, and the less likely it is that an employee can allege that you run a workplace that isn't complying with the law. Because again, you can say, look at all these policies we have, we keep them up to date, and we use them. So it's a really great compliance tool. Finally, I mentioned I would talk a little bit about the recent legal changes that happened last year under the Closing the Loopholes law. There was a lot of media attention on this. Just to explain what changed, there was a new introduction of something called the right to disconnect, which was all over the news for a little while, which basically was a new piece of law that's come into force that gives employees a right to refuse contact from their employers outside their usual working hours. Now, it was a little overblown in the media in terms of how it works. If you need to contact them for an important purpose, if it's part of their job, and it's necessary to perform their duties, the right to disconnect doesn't stop you from contacting them. It also doesn't stop you sending them a message. It's just that they may not have to reply to it if it's not related to work and it's not an urgent matter and there's not a reasonable operational reason why they need to. And if they challenge it, there's a big process for it to actually turn into a serious consequence for the business. They've got to talk to you about it. Then, it has to be considered to be unreasonable, et cetera, et cetera. So as long as you're reasonably contacting people and, having open conversations with them about when, you might need to contact them outside work hours, it shouldn't be a big disruption, but it has strengthened their rights to at least be able to say to you, hey, I don't want to be contacted at this time. Unless there's a really good reason for doing so, and you generally have to comply with those requests. So that's an important change for people to be aware of. I mentioned earlier, the casual employees have this right to notify you after 12 months of consistent work, or it's actually 6 months for businesses who have under 15 employees, and ask to be converted to a more permanent engagement model. You don't have to say yes. You can refuse it because you can't afford it. You can refuse it because it doesn't make operational sense. So don't feel like every time you take a casual, you've only got a 6 month or 12 month window. But important to be aware that they can make that request, and you have to have at least some reasonable grounds for refusing it, or it could be challenged. And finally, there's some changes that were rolled out for people employing gig workers, through platforms like Uber Eats or the other sort of marketplace platforms. And again, that's may not be applicable to most businesses here, but if you do run a marketplace business, worth looking into that a little further. They also refined that employee and contractors test. I ran through that already, but the law is really quite serious about this test and really trying to there was a couple of high court cases in the last few years that basically tried to weaken the test and say, if someone wants to be a contractor, let them be a contractor. But last year, the law was strengthened to really reinforce that for those trying to engage in sham contracting, there will be penalties. If you're engaging small-scale contractors, you can't have two contracts that are too one-sided. So again, probably best to get your contractor agreements checked by a lawyer to make sure that they are complying with these new laws about what you put in there. And finally, in general, workplace enforcement is getting a little stronger because there's been many cases, particularly in certain industries like hospitality, where employees have just been breaking laws, and some reports came out showing those numbers. So the regulator's been given more power. So again, it's a great time to get compliant with employment laws because it is possible that there'll be more enforcement over the next few years. So that was all of the presentation. I'm happy to stick around and answer any questions. I can see 3 in the chat that I'll run through now. But for those that are going to drop off, thanks so much for attending. And as I said, there'll be some recordings online. So Melissa's asked, who's legally responsible for payroll? What if you have an administrative staff member who runs payroll and leave and they make a mistake, e.g. an underpayment or a miscalculation of leave owed or taken? The employer is, so the company is. So even if an individual person makes the mistake, it is the employer that would suffer the consequences and would be fined. Whoever has the ABN number that's been signing the agreement. Usually, it's a company if you're set up that way. So it really is on the directors of the company to make sure that they've got robust payroll processes set up so that mistakes can't happen. And if there are mistakes, which do happen from time to time, they're very quickly rectified before it gets escalated to a real legal issue. So yes, it isn't like you could sort of say, oh, we did our best, but our staff member made a mistake. Under the principle of what we call vicarious liability, it's the employer that's actually liable, even if it is an employee or a contractor, for that matter, that makes a mistake. Katie said, I recently heard that there are going to be some changes where people overseas can be entitled to Australian employment standards and benefits soon. I'm not across, not to say that there isn't, I'm not across any soon forthcoming laws that are adding more clarity to that situation, but it is certainly a legal issue that that exists, and anyone who's engaging in, as I said earlier, engagement model of involving people overseas, I think should be considering legal advice on this topic. And yes, I haven't heard about the changes, but that doesn't mean that there aren't any. I may have missed the news on that. But as far as I'm aware, I don't think there's anything that's come into law yet that makes the situation any more clear than it currently is. Do innies have the right to disconnect? I'm not sure what you mean by innies. Maybe you could clarify that, Rick. Jagwit said, may I have employment contract templates, please? You can reach out to our team at sprintlaw.com.au, and we can give you a quote for putting together employment contracts. There's discounts I think I mentioned at the beginning of this presentation at the moment. That looks to be all the questions. Thanks everyone so much for attending. I hope you found this useful. As I mentioned, we do this every month. So I think we've got one coming up next month you can register for online. Otherwise, any feedback will be appreciated to our email. I'll see you all next time. Have a great month.